We'll hear from the appellant.
Thank you, Your Honor. Good morning.
Morning.
I am Daniel Bryant of the Montgomery County Bar. I represent the appellant in this case, the ex-wife, Tetyana Ewald. Taking us back, well, first off, if I could reserve 3 minutes of time.
3 minutes.
Thank you. Taking us back a little over a decade, 2013, 2014 timeframe, Middle East, Jordan. Miss Ewald, at the time, Miss Kutova, Ukrainian citizen, grew up in the Ukraine, professional ballerina, meets an American soldier, Mr. Ewald, active duty. They find each other there. It's kind of a storybook start, obviously not a storybook finish. They meet each other. She's got a small child, small son, very young. Fall in love. He brings her back to the United States. She's never been to the United States before. Her son's never been to the United States before. They come back here, or they come here entirely based on this marriage. Mr. Ewald goes through all the immigration paperwork, all of those steps, signs as her, caretaker. She becomes a legal resident here. Does the same thing for Miss Ewald's mother, which they call Babushka, comes over. They start to live their life here in the United States. He continues to be active duty soldier. Miss Ewald holds a number of modest jobs, never making really more than maybe $2,500 a month. She does some teaching. For a while she works at Opryland Hotel. That's where she was at the time of the divorce. The two parties have 2 minor kids together. At the time of the divorce, they were about 5 and 7. So now about 7 and 9 at this point.
Counsel, how old is the stepson?
Right now he is 17.
When does he turn 18?
In end of May 25th of this year.
Okay, so after he turns 18, and one of the challenges in this case is related to the parenting plan and time, and with regard to the parenting plan. I'm curious as to whether that issues related to stepson, not the other issues in the case, but the issues related to the stepson are fast on the verge of becoming moot. After he turns 18, is there any basis, and they're interesting legal questions, but is there anything that would render any decision as to him anything other than moot once he turns 18 years of age?
Well,
and again, not talking about the other issues in the case, just
right.
the issues with regard to the stepson. And there's 64 days after this court issues
right.
a decision
right.
before a mandate issues.
In reality, it may not matter. That child is with dad.
If once he turns 18, is that issue moot from your perspective?
I think on a practical level, yes. Nothing that any court could do at that point is going to change, is going to reverse time and make this child a minor again. However, some of it goes to just what's right. Some of it goes to just...
There's nothing that we could change, though, after that point, right? And there's nothing, this court, if an order comes down in June, or decision comes down in June, there's nothing this court can change in the real world with regard to where the stepson is for 200 plus days.
That's right. At that point, he can choose where he wants to live.
Is there you were starting to get into the issues about how much he's making at Opryland. Is there any ruling in this case on the question of alimony? And or is there just no ruling whatsoever on the question of alimony?
There is no ruling whatsoever. That was point number 5, I believe, in our brief. It's not a long-term marriage, but it's a lengthy marriage. It's a 10-year, middle-length marriage.
And alimony was requested here.
That's correct.
Okay.
That's correct. I wasn't trial court attorney, but they put forth all of the facts that one would put forth for an alimony request. She requested in her petition or complaint.
Yeah. So was it pled and was it requested in the complaint for divorce?
It was pled. Yes.
Yeah, okay.
And there's no ruling rejecting alimony. There's no, I've decided not to award alimony.
That is correct. Okay. The final decree is completely silent as to the issue of alimony.
Please.
At some point, wife filed a motion to alter amend.
That's right.
And that did not include anything about alimony, is that correct?
That is correct as well. And I wasn't there for that. I don't know why that was done that way. However, all I can say there is that, a civil matter not raising that issue in the motion to alter amend doesn't waive the issue. It's still an active issue. Why it wasn't done, I don't know. I was very kind of disappointed to not see that in there.
Because it did raise child support.
That's correct.
Calculations.
And a few other issues as well, yes. But the parties obviously were contemplating alimony even in the trial. Husband, submitted a financial affidavit showing his expenses and income. And that's typically only done, that's not relevant to child support or property division. We really only do that in a case where alimony is an issue. So obviously, Dad was, defending that issue as an active part of the case. And the parties put on the facts to go toward the 10 plus factors in an alimony case.
Did the wife also submit an affidavit of expenses and income?
I didn't see one. Did not see one. So could not answer that, other than no, I did not see one. So just very briefly back to the issue that, as the court indicates, may be running moot soon. There's no basis in law for awarding this father, and it sounds like he was a good stepfather to this child, and he did good things for this child, but there's no basis in law to say, okay, you have custody now. But then turning to the other two kids, who are still elementary school age at this point, have many, many more years as minors.
And I take it the stepson was not adopted, is that correct?
That's correct. There was never an adoption proceeding. Stepdad is stepdad. Ex-stepdad at this point.
But you would acknowledge, if we're able to get to this issue, that being named a primary residential parent, the way Tennessee thinks of parenting plans is we have a primary residential parent, but then we have the alternate residential parent. So it's really not a question of custody in a parenting plan.
Regarding the stepchild?
Yes.
I would say yes, but in this scenario, father or stepfather was awarded custody of that child. The child is with him so allegedly with mother 80 days, so with dad 285 days a year.
Didn't the trial court just say that the stepchild would follow the same plan, the same schedule as the two children of the marriage?
That's right.
And that's the way it fell according to what was ordered for those marital children, right?
That's right.
So the trial court never said, stepfather, you have custody of this child. You see, the trial court order said stepfather has visitation along the lines of the same time that the marital children are with the father, essentially.
Well, I would like to think of it that way, but in reality, the parties have exercised this as father having custody. That's how everyone has interpreted this order.
But what does the order say, though?
The order simply says, okay, it is noted the court would have preferred, given child's age and significant maturity level, that his discretion be weighed in a specific visitation schedule. But given the animosity evidenced between the parties, the court does not believe that this would be viable. As such, the court finds that visitation with child should be consistent with that of the two minor children born of the marriage and shall be governed by the parties' parenting plan adopted herein. So it's a little unclear what was meant, and the parenting plan that's attached to the decree lists that stepchild. It doesn't give any more detail other than saying 285 days to dad, 80 days to mom. The parties have operated with that child living with dad, stepdad. So it's kind of an inexplicable situation to me.
Which may be moot anyway.
Maybe. But even if we reach that point, I mean, mother would want an order saying that this was wrong, for this family.
Isn't that purely advisory at that point? And if this court was to issue a decision saying, well, if this still mattered, then this is how we would decide it. Isn't that almost definitionally an advisory opinion?
To some extent, I'd say it's a legal issue. It's a legal issue that it existed at the time of.
But it doesn't have any effect in the real world, does it?
It may actually, because, for example, for tax purposes, if she should have been claiming this child on taxes, whereas now father has been claiming the child, that's a potential issue that could be taken to the IRS in retrospect after the fact and altered. That's a small scrap of things compared to the reality of what's going on, but it is an issue that still exists potentially.
Well, that's clever, but I don't think that works in this case, does it? Because the parenting plan doesn't say, I mean, as Judge McGee points out, the court just wants the son to follow the parenting plan for the two children of the marriage, but it doesn't designate the father as being able to claim the stepson on his taxes for filing purposes.
That's right, but the normal IRS rules would be you claim the dependent in your home who's there for more than half the time. What is it, 50 seconds?
Which he would have been either way, because the timing and the time period isn't going to change on that in terms of if there's a ruling in June, he's been there for the time one way or the other.
I suppose.
I want to ask you one question about the marital property division. Did the court make any marital property division?
Partial. The court discussed the home, the real property, and gave an order as to what would happen with the real property. I think the court also indicated who was going to get what vehicle. Court said, you take whatever debts are in your name, you take what's in your name, but there was no valuation of there was no valuation of debt, there was no true valuation of bank accounts or vehicles or personal property. So I would say it was a partial ruling on the property.
And you are taking issue with that, with what the court did?
We simply we would have wanted, if we'd been there, that the court list each piece of property.
Did you
give it a
file a
value.
Rule 7 table?
We didn't, because we really couldn't, because we don't have the values. We don't have.
You have the values on the house, don't you?
Just the house, yes.
And the cars?
Don't really have the values of the cars. The court never listed the value or the debt amount. And I know mother's car had debt on it.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Bryant. We'll hear from the appellee.
Good morning.
Good morning.
May it please the court, I'm Roger Manus from Clarksville. I represent the husband, Dan Ewald, in this matter. I'd like to introduce my co-counsel in this matter, whose name is Colleen Hyder, seated on the front row. She has labored mightily on this case with me since sometime in early 2021. So what I would like to do today is focus on essentially three issues that I think the court has already addressed in the questions to Mr. Bryant. First, I want to, Judge Koch, long ago when he was Judge Koch, and see to where Judge McBrayer is now, told me one time that in a divorce case, that I was very carefully choosing my words. And so with all due respect to my colleague, who I'm good friends with, Mr. Bryant has very carefully chosen his words. There is no, in answer to Judge McGee's question, there is no award of custody of this stepchild to my client, nor was he designated the primary residential parent of the stepchild. The parenting plan makes reference to the stepchild in a note below kind of at the bottom of the identification of the children, that the parenting plan would apply to the visitation schedule for for the stepchild. So I think a proper framing of that issue would be more referring to it as maybe a tantamount, having been tantamount to an award of custody or primary residential parent status. But the reality is, the direct answer to Judge McGee's question is no. There is no order in the court which says Mr. Ewald is awarded custody of the stepchild or primary residential parent status as such.
Counsel, I want to ask you the same question I asked opposing counsel, which is, let's say that there's a decision in this court that comes down in June, just the stepchild issue, not the other issues in the case. Is that issue moot? As of June 1, is that issue moot? As
of June 1, that issue would be both, counsel said, practically moot and legally moot. At that point in time, this young man can go anywhere he wants to. He can reside anywhere he wants to, and any ruling by this court would be, I guess, precatory or advisory in that respect. So as a practical matter, we are creeping up on complete mootness, legal and practical, on that issue in this case. So moving on then to the alimony issue, I want to address that so that the court will know what role we played in that. We didn't, we put on proof at trial of my client's income and an income and expense statement. I don't think that counsel for Miss Ewald did that. That issue was essentially omitted at trial by implication in that fashion. At that time, the parties had only, I think at that time they'd been married 9 years. She's a highly educated lady, has I think a master's degree from the Ukraine in some art discipline, I think. Taught at Austin P as an adjunct at some point, was earning about $50,000 a year at the time of trial on it, and was in good health, good physical health, and so forth.
Counsel, did the trial judge rule on alimony here? I mean, in looking at it, it seems to me it's not that we have a clear rejection of alimony. We have silence.
That's correct. No, that's exactly correct, and I think that's the way I briefed it. This case was tried in January of 23 and in July, two different dates in July, and then the court ruled from the bench on July 31 of 2023 and made no reference whatsoever to the alimony claim of the wife. The court directed us to prepare the decree. My practice has been and continues to be when I'm working with a verbal ruling, of which I think I had a transcript in this case, to track the verbal ruling of the court as precisely as I can. Now, that's not the practice of everybody, I understand. Some lawyers feel like it's okay to add materials that were not addressed by the court, but it seems to me that when a court rules from the bench, and we have a verbatim transcript of that, then the obligation of the lawyer is to incorporate as near as possible the ruling of the court into the decree, and that's what we did. And there is no, frankly, there is no ruling addressing that. I don't know that it even occurred to me that it was an issue. It didn't get raised in the post-trial motion to alter or amend. I have argued in my brief that based on the Court of Appeals rule addressing matters that should have been addressed to the trial court, that it's waived. I understand that that's may or may not be the case in this particular instance. That's most often related to evidentiary rulings and matters that are curable as a result of jury trials and so forth. But the rule reads as the rule reads, and it was a matter that could have been brought to the attention of the trial court at the time, and the trial court, I'm certain, would have addressed that matter.
If I recall your brief correctly, you raised the absence of the T7 table here.
I did.
Opposing counsel notes that there's some challenges in terms of a T7 table. What's your response to that?
I don't agree with that at all. Some cases are complicated from a property standpoint. The one Mr. Caparella argued just before me from an income and property standpoint may have been far more complicated than this one. My client testified as to the value of the house. Miss Tetyana said, I don't disagree with that. I accept his estimate of the value of the home. He gave a fairly precise estimate within the brackets of a few $1,000s of the mortgage obligation on it. The court ruled within that range. Then the record will reflect that actions were taken later to obtain to pay off Miss Ewald per the decree of the court. The court had to make trial court had to make a Rule 70 order to direct the clerk and master to sign the deed, the quitclaim deed, conveying to my client at the time of the refinancing on it. So all that was accomplished, and these parties really didn't have anything in the way of savings. The proof was my client had a 25-year military pension, which is, as the court knows, is essentially a defined benefit pension. She was awarded her coverture fraction interest in it.
And your client was also receiving a VA disability, is that correct?
That's correct.
That receipt of disability didn't affect the pension amount? It wasn't reduced by the amount of the disability in any respect?
No. I mean, what the court did on that was award and what the courts tend to do now on these cases is determine the number of months of creditable service and the number of months of marriage that overlap the creditable service from which you can derive the coverture fraction, applied to multiply that times 50% times, and then you come up with a percentage usually somewhat less than, well, either at 50% or less. So
on the child support, there seems to be acknowledgement of error here on the calculation of the hourly amount that the wife was receiving here. In light of that, does this case have to go back anyway for the court to recalculate child support then?
Well, I think so, but I think at that point, now that the case is 2 years old, essentially, from the date of the trial, and I think the parties are under a continuing obligation probably to provide updated financial information. So we're prepared to do that. I mean, I don't think that's a problem. I mean, we were off by $1, and that was my mistake. I think I advised Ms. Hyder to plug in $24 because I was of the impression that the testimony had been $23 to $24 per hour. I went back and couldn't find that anywhere in the record, so I just acknowledged the mistake.
And on the child support worksheet, I'm assuming that it listed just 2 children, correct?
Correct.
Okay.
Yes. On the worksheet.
Yes.
Yes. Correct. Yes. 2 children on the worksheet. So, as I see, the only other issue I think that's of significance in this case, where this case is probably outside the usual norm now, is the parenting plan and a primary residential parent status and parenting plan in respect to the 2 younger children, non-stepchildren, they're children of the marriage. And what I would say about this case, my old partner used to say, late partner, Dempsey Marks, used to say that you catch more flies with honey than you do vinegar. Well, the problem with Miss Tetyana Ewald in this case is that you always get vinegar, and usually you get something much more vitriolic than that. The history of this case has been, and the record is replete with it, that Miss Ewald goes from 0 to physical violence and serious property damage in the blink of an eye. And the pattern continued. We tried the first day of this trial in January of 23. We proved up a number of serious incidents of both physical assault and $5,000 worth of property damage to my client's truck with a sledgehammer and a skillet, iron skillet. Between that hearing, in the July hearing, more incidents occurred that resulted in Miss Ewald being arrested. So the case law that out of this court says that the best interest factors are not factors that we just add up and balance up and count. 6 of them favor the wife and 7 of them favor the husband, and the husband therefore wins 7-6. That's not how it works. Some of these factors are more important in some cases than others. And in this case, the anger and acrimony and vitriol of the wife against the husband is so profound that the trial court, I believe, determined that the only way these children would be in a situation where one parent would provide a stable home for these children that did not interfere with the lives of the children and did not leave the children in an environment of conflict, constant conflict, was to award primary residential parent status to my client, which is one thing. And then what I would concede to be, nowadays at least, at one time it wasn't unusual, this particular parenting schedule, but it is somewhat now. But I think when the court looks at the record in this case of Miss Ewald's behavior, she physically assaulted, in this case, every single adult, her teenage son, and on one or more occasions did substantial property damage, burned all of my client's clothes, or half of his clothes one time. I think she didn't burn the other half because she couldn't get to them. So there's a degree of anger and unrequited bitterness on the part of this person that really the only way to cure it in the context of this parenting plan was to go with the one that the court went with on it. So, an example of that would be this stepchild about whom we've talked was kept from any contact by my client until the court for many, many months or a year or more. He treats this man as if he were his own father. The proof's undisputed on that. He's not seen his real father for 10 years or more, a long, long time. And my client treats him as his son. But she kept him away, physically away, as long as she had the throttle in connection with that child. She kept him physically away from any contact at all or any communications with my client until the trial court ruled to the contrary. That's a window into who she is and how she's going to govern herself going forward. Looks like I'm on the verge of being out of time. I would ask if there are any questions I can answer other than what we've already addressed. So.
Seeing none, thank you, Mr. Manning.
Sure.
Mr. Bryant, we'll hear from you on rebuttal.
Going specifically to the 2 younger children, the children of the parties, these are 2 parents who live locally, both live in Clarksville. We've got a mother and children who have literally seen each other every day of their lives, other than maybe a couple days here and there. You go from that to now you're going to see your mom 80 days a year? That's not maximizing parenting time pursuant to statute. It's ignoring the factors. The court goes through the factors, somehow finds that dad has been the primary caregiver for the kids on multiple factors. That's inexplicable. The facts don't. The record does not support that in any form or fashion. Mom has her grandmother. Both parties acknowledge that babushka is a major part of the kids' lives. She's attached to mom. So finding that they should now only see their mother 80 days a year is an unreasonable denial of their rights as kids. Mr. Manis has pointed out property damage claims, violence claims. If you look at the factors, the court doesn't point that out as a ground for finding this parenting plan. The court in factor 2 does say the level of acrimony that clearly exists between the parties, co-parenting will continue to be a struggle. The willingness to co-parent favors father. The record showed that there was a lot of tension back and forth. There was a lot of issues on both sides. And really, there wasn't very much of a clear finding that mom was the, most guilty party. There was a lot of gray and a lot of mush in these facts. And to simply say they had a lot of tension, many divorces have lots of tension. Many divorces have much more acrimony. That doesn't mean the kids should be separated from one parent. And given the extreme nature of this parenting plan, they have been separated from one of their parents. And all control, including half the decision, or 2 of the major categories of decision making, went to father on this parenting plan. You look at the schedules of the parties. Dad was going to be working as a firefighter. He's going to be doing 24-hour shifts. No, they're going to stay with dad primarily. Taking the factors as a whole, they were misapplied as individuals, and as a whole, just a gross conclusion of what's right and best for these children. Thank you.
Thank you, Mr. Bryant. The case is submitted.